Three cases for argument today, and we are prepared to begin with the first one of Black versus Bryce. We'll hear from appellant's counsel here.
Good morning, Your Honors, and may it please the Court. My name is Thomas Fox, and I represent the appellant, Carol Black, Plan Administrator of Schletter, Inc., the debtor in the underlying Chapter 11 bankruptcy case. I would like to reserve 2 minutes for rebuttal. This appeal challenges the U.S. Bankruptcy Court for the Western District of North Carolina's grant of summary judgment in favor of Dennis Bryce, the former Chief Executive Officer of Schletter. The District Court affirmed the grant of summary judgment. Both courts erred, and we respectfully ask this Court to reverse and remand for trial. Briefly, this case involves the untimely collapse, bankruptcy, and liquidation of Schletter, a North Carolina-based corporation that designed and manufactured solar panel mounting systems for commercial applications.
It was, but it's also a corporation that's almost totally owned by a German parent corporation. Only 5% of it was there, and I understand there's I don't know if it's unique to German law, that 5% to go into treasury. Is that done in the United States too?
Your Honor, my understanding is that that is somewhat common practice in Germany to have 5% of shares reserved. Now, it is our understanding that at some point in time there was an individual named Martin Hausner that held that 5%. I don't know about him. That's not important. He's gone out of the picture. But I'm just, when you say a North Carolina corporation, it's really German in the sense that 95% of it is German, and then that 5% is in the treasury there. I don't know what they own of themselves, but all right, proceed. Judge Floyd had a question.
I had a question. Don't you think it's relevant for us to identify right out of the chute when Schletter became insolvent? Can you tell us that date?
Yes, I can, Your Honor.
And do the two parties agree on that date?
Well, Your Honor, I guess we'll have to leave it to Mr. Sims to tell us whether his client agrees, but we have an insolvency analysis that was prepared by BDO, which was the Official Committee of Unsecured Creditors financial advisor appointed in the Schletter case. They prepared a detailed insolvency analysis, and they determined that as of June 30th, 2017, Schletter was insolvent on several bases, including a balance sheet analysis and an ability to pay debts as they come due analysis. So, and they assert further in their report that Schletter continued to be insolvent after that date and consistently throughout the pre-bankruptcy and then into bankruptcy.
And my follow-up to that is, who bears the burden of proving the timing of his insolvency?
I would acknowledge that it would be our burden to prove that. And I would note, Your Honor, that our evidence of insolvency is uncontroverted by Mr. Bryce.
The importance of that issue is what?
It's very important.
Why?
It's important because it bears directly on whether Mr. Bryce owed fiduciary duties to Schletter.
That being if it was because it's a subsidiary, with the law basically saying his duty would go to the parent corporation, the exception being if it's a subsidiary and is insolvent, then you have a different picture than if it's solvent.
That is absolutely correct, Your Honor.
You're saying it was insolvent while he was still CEO.
That is correct.
Critical point.
I agree with that, Your Honor.
But, counsel, what is the evidence of that? The BDO time period begins after Mr. Bryce was out of the picture.
The BDO analysis started before the date on which they assert that Schletter became insolvent. So what you see here is that in periods preceding that date, June 30th, 2017 occurred shortly after the GMAX product launch, which is the event that we assert really drove this company into bankruptcy. BDO acknowledged that in 2016, the year prior to when this occurred, Schletter had generated positive EBITDA of I think about $1.8 million. In 2017, when the GMAX launch occurred, the EBITDA dropped to significantly negative levels.
But the BDO report, there's no expert opinion that the company was insolvent at any time that Bryce was the CEO. Is that correct?
BDO's assertion is they did not opine on that the company had become insolvent at a date prior to June 30th, 2017.
If we find Schletter to be a wholly owned subsidiary of Schletter Germany, do you agree that we would apply the business judgment rule in our standard of review?
Well, Your Honor, I'm going to get into a Karamark discussion in a few minutes, and I think we would contend that we would not apply the business judgment rule in light of that. But I think there was a threshold issue that we really needed to talk about, and that is whether
But did
whether.
you hear the premise he said? If we determine that it is wholly owned, then what's the answer?
If it is determined that it's wholly owned, I think there's a two-step analysis we have to go through here. First off, did Bryce even owe a fiduciary duty to Schletter and its creditors? And then secondarily, what is the standard upon which we're going to review Mr. Bryce's conduct? So turning to that first issue, even if we're going to stipulate that Schletter was a wholly owned subsidiary of Schletter Germany, at some point in time, Schletter became insolvent. When Schletter became insolvent, or even entered the zone of insolvency, duties expand. Duties expand from the parent company to the enterprise and its creditors. So we have that. Then we have the secondary step of whether Mr. Bryce can be held responsible for his conduct or his omissions at relevant periods of time. And I think it might be worth us jumping over to that discussion right now.
Counsel, if I could though, you refer to the zone of insolvency. As I read the Giwala case, either a company is insolvent or it's not. As I read that case, the Delaware Supreme Court has put aside this concept of there being a gray area. What do you make of that?
Your Honor, if that is what Giwala stated, I'm not going to try to create new law here. We do have a date, according to the BDO analysis, as to when this company was insolvent. And if that is the date we have to work with, that is the date we have to work with. Obviously, actions that occurred prior to that date are relevant.
Explain what you're saying. I'm in light of the question. You said if that is the law. I mean, take it that it is the law as the judge has stated it. What's your answer?
My answer would be then that the duty wouldn't shift until there is an insolvency.
Well, I have one more baseline question while you're thinking, because I had about 5 questions I want to get in my head. My last one is, did Shetler, and it may be better addressed to the other party, but has Shetler identified any other conflicts of interest that would cause us to use a heightened standard of review?
So as it relates to Bryce, I think the only conflict of interest that would be easily identifiable, since Bryce did not himself have any ownership interest in either Schletter or its parent company, would be the fact that he was also the CEO of Schletter Canada. Now, the Schletter Canada issues, I think, are probably, from an economic perspective, fairly modest in the grand scheme of things. But there were allegations in our complaint that Mr. Bryce caused certain products to be sold by Schletter US to Schletter Canada at cost and not at profit. And that resulted in a significant receivable being accrued at the US end that obviously was never collected. That was only, I think, several $100,000, though, out of the approximately $12+ million of losses that occurred as a result of various forms of conduct, including the relinquishment of the intellectual property related to the GMAX system, as well as the direct losses that were incurred as a result of the rushed launch of the GMAX system. Your Honors, I'd like to now turn to the appellant's Caremark claim, as that is the second primary issue that was addressed by both the bankruptcy court and the district court in their respective opinions.
So with the two claims, you have a duty of loyalty and a duty of care, and the Carmack claim falls under the duty of loyalty?
That is correct, Your Honor.
Okay, go ahead.
Okay. Under Caremark and its progeny, there are two alternative bases for oversight liability, which under Delaware law sound in the duty of loyalty. First, that the fiduciary utterly failed to implement any reporting or information systems or controls, which are known as information systems claims. And second, that having implemented such a system, the fiduciary consciously failed to monitor or oversee its operations, thus disabling it from being informed of risks or problems requiring its attention, which are known as red flags claims.
I think the Carmack claims are probably the most difficult thing to prove.
Numerous courts that have addressed Caremark claims on a red flags theory have indeed stated that. They have asserted that these are difficult claims to prove up under Delaware law when contrasted with claims that assert that a board of directors failed to implement controls that were related directly to violations of law. So
tell me why it is this case is going to meet that very difficult burden of satisfying its Caremark claim.
I think there's a lot of distinctions to be drawn here, Your Honors, from the various cases that have been cited in the appellee's brief, and frankly in our brief, to the situation we are dealing with. I think there's a few important things to note. First off, there is very little jurisprudence out there concerning officers' liability for under Caremark. Most of the cases deal with director liability under Caremark, and aside from several courts stating that a claim can be sustained under Caremark against an officer, I'm not aware of any reported decisions that directly deal with that issue. Moreover, we have a situation here where most of the
Well, it's
reported
a tough
decisions.
thing to prove.
Pardon me,
You've
Your Honor?
got someone, in the instance of this CEO, you had a product there. I had to look that up because I hadn't seen one of these solar panel type things up there to kind of figure it out. I think that's okay because it's public record, but he's trying to improve the company. I mean, he goes to get approval from the parent company to do it. Then he undertakes to get contracts, and he's working hard to try to make this thing work. He has some deadlines and some serious problems along the way in trying to get it done, and it, ultimately it just fails, I guess. But maybe the reason you don't see a lot of cases on it, because when you have an official who's doing that and working hard, it's more of a poor business decision than it is someone who is doing something in a way that is just wrongdoing for a corporation to meet the Caremark standard. So how is that different here for Mr. Bryce?
I think it's different here. Let's kind of take it piece by piece here. As an initial matter, I don't think there'd be any criticism levied upon Mr. Bryce or any of the other leadership at Schletter for wanting to develop a new and improved product and bring it to market and hopefully generate profit from the sales of that product. That's
Who
laudable.
developed the product? That was some question about that too.
Whether-
That the product was developed either by the U.S. company or the German, but you were paying fees to the German.
That is correct. Let me address that for a moment, Your Honor. So the district court came to the conclusion that the GMAC system was nothing more than an improvement on the previous FS Uno system, a contention that we disagree with, and a contention, frankly, that we think would be worthy of being more further developed at a trial. There were numerous different new components to the GMAC system that were not shared with FS Uno, different mounting, multiple different parts. Part of that is kind of the reason why there were so many issues with GMAX, because there were a whole host of new parts, new and unique parts that were a part of that system that were wholly developed by Schletter US. This was the first time that Schletter US had actually developed its own system, as opposed to simply manufacturing and selling a system developed by the German parent company. So, starting with the premise that there is certainly nothing inherently wrong with wanting to develop and go to market with a new product, we have to look at what happened here with the development of this particular product and its highly premature launch. We had numerous new components that were still in the process of being developed when there was a rush to sign contracts containing onerous liquidated damages provisions. We had a company that did not have the capability to manufacture enough components to meet the demand of its customers, who had ordered $40 million worth of product. And I should note that the revenues of Schletter in 2017 were about $80 million. So this was a very, very significant component of the company's revenue, approximately one half of that revenue, and was expected to become a larger percentage of the revenue in future years had the system worked out, which it did not. So we had the push and pull between numerous entered into contracts that had very onerous liquidated damages provisions, coupled with the fact that we had a system that wasn't ready. The parts hadn't been fully developed, no field testing had occurred, and yet it was decided that we're going to go launch this product. It wasn't ready.
Mr. Fox, assume that the business judgment rule applies to those decisions, what is your best argument that those decisions constitute a violation of the business judgment rule, or that notwithstanding the business judgment rule, there is a Caremark violation?
Certainly. So we would contend, Your Honor, that a reasonably prudent person in Mr. Bryce's position would not have allowed this product to go to market, given the lack of the field testing, given the lack of the fact that the products were not up to specifications, were not going to meet the customer's contractual requirements, and were almost certainly going to cause breaches of those contracts, which in fact did happen.
So it was the entry of the contract into the contracts that you contend
Well,
was the violation?
I'm sorry, Your Honor, I didn't mean to interrupt you. I would contend that the entry of the contracts was premature when you don't even have a product that's ready to launch. Had the company simply waited, and this was something that was being discussed internally, we had people that had expertise in the development of products like this saying, this is not ready. And I think if there had just been a little more time and a little more care taken to fully develop out the products, do a field test, install it at a location so that it can confirm that the products actually worked as they were supposed to work, and then enter into the contracts, you would have not, this company wouldn't have gone into bankruptcy. This company would
Product
not
is
have
no
become
good if you
insolvent.
don't have contracts. I mean, you can say we can do it, and contracts are time sensitive in many instances. I mean, it's kind of difficult to second guess CEOs of companies as to why they do stuff. And, you know, if it works, everybody's happy. But where in anything you said, following up on Judge Abraham's questions, where is the bad faith on his part? I mean, yeah, things didn't go well. It was delayed. You shouldn't maybe gotten these contracts so quickly. But where is bad faith in that McDonald's would require?
Your Honor, we are not contending that Mr. Bryce had ill intent in what he was doing. I have no doubt that Mr. Bryce sincerely wanted.
What about
the
my
company to succeed.
term, bad faith?
Well, bad faith.
Did he have
though,
bad faith in what he was doing?
a conscious disregard of the red flags is tantamount to bad faith under McDonald's. And that is what we are
So
contending.
you are
happened
saying
here.
it was bad faith?
We have to say it was bad faith because we can't
Certainly
sustain
do.
a claim otherwise. So because of the conscious disregard of the red flags that had been identified by the experienced professionals at Schletter, who said this product is not ready for launch, it is not ready for installation at customer sites, yet we went ahead and did it anyway, that, in our view, is tantamount to a bad faith and therefore sustains a Caremark claim. I know I'm getting a little short on time here, so I'm going to have to skip ahead a little bit. Your Honors, the appellee asserts that essentially we cannot assert a Caremark claim and cites several cases in support of that proposition, Citigroup, Goldman Sachs, Walton. And we assert, Your Honors, that our situation is distinguishable for several reasons. First off, we certainly acknowledge, the Citigroup decision really came down to macroeconomic factors that were outside of the control of the board of directors. Here, that is not the case. We have an individual, Bryce, who was the CEO of this company. This company had a very limited scope in terms of what it did. Bryce was very well aware of what was going on. He was meeting with the Schletter management on a weekly, daily basis, recognized that there were specific micro issues with this particular product, and yet allowed it to go to market. If we look at some of the other cases, like Goldman Sachs, where the conduct of the board of directors was criticized in terms of providing certain compensation structures to Goldman professionals, I think this is a completely different situation as well. I think one thing that really distinguishes our and it looks like I'm out of time. May I finish this?
You are indeed. We'll hear back. You got 2 more minutes.
All right. I
After
will-
this is over, let's hear from Mr. Sims on this
Thank you.
case.
Thank you, Your Honor.
Thank you for that part of the argument.
Good morning, Your Honors. It's Charles Sims on behalf of Mr. Bryce. And it may it please the court, I think as the court has seen in the argument, in a nutshell, what the administrator seeks in this appeal is to have this court impose fiduciary liability on a corporate officer because with the aid of hindsight, the administrator contends that the corporate officer's pursuit of a board-approved business strategy to develop and market a new racking system, the GMAX, failed.
Address
Ultimately
the
leading to-
question Judge Floyd posed in terms of solvency date.
Okay.
Judge Aberson also.
First of all, I think it's very important to stress this point right now, Your Honor. So much of what was being argued to this court by appellant's counsel is not a factual record that's before the court. So there's all this reference to the BDO report. The only reference to the BDO report is in the complaint.
But are you
It's
saying
not-
we can't consider it?
Yes, Your Honor, because it's not evidence. We came in summary judgment on Rule 56 and presented evidence to establish our foundational basis that the plaintiff couldn't prove their case. They were under the obligation to come forward with evidence, admissible evidence, that would raise a genuine issue of material fact. they did not present the BDO report as evidence before the district court. And as this court, as well as the district court, are tied to the record that's presented to the to the bankruptcy court when it considers summary judgment. The BDO report is not evidence that was presented to the court. But put that aside. Even if the court wanted to look at the BDO report, what counsel's correctly stated is that BDO found only that there was insolvency on June 30th. Mr. Bryce's employment was terminated on June 27th. And as Judge Abelson stated, in the Giwaller case, the Delaware Supreme Court has made absolutely clear that the zone of insolvency is irrelevant. But what the court, and I actually will cite to the court what the Delaware Supreme Court said. It said, when a solvent corporation is navigating in the zone of insolvency, the focus of Delaware directors does not change. Directors must continue to discharge their fiduciary duties to the corporation and its shareholders by exercising their business judgment in the best interest of the corporation for the benefit of its shareholder owners. And as we cited the Abelson case in our brief, the Delaware Supreme Court has said in the context of this situation where we have a wholly owned subsidiary, the duty of Mr. Bryce, the officers, and the directors of that company is to further the interest of its parent company.
So you think this case is real simple, don't you? Because what you just said, if it's not insolvent during the time that he's CEO, which you say even receiving the BDO report, he was gone 3 days before that came out. And it's wholly owned with the German company over there with a 5% if we consider that to be wholly owned. That's the end of this case. That's what, a one paragraph opinion?
It is, Your Honor. Well, and you have to deal with the Caremark claim, but it does. It ends the case on this issue because this is a business judgment rule. I mean, the evidence was overwhelming that we presented to the bankruptcy court. This was a situation, and I'll say this, the bankruptcy court noted during the summary judgment argument is courts are not in a position to second guess business executives on these types of decisions because the record evidence established that prior to kind of going down this road that Mr. Bryce did with his strategy on the GMAX, the company was suffering severe economic distress. Its product was no longer viable in the market. And there were competitive issues coming with the Chinese and flux into the solar panel and into the marketplace. And so he needed to develop a new product. And here's what Mr. Bryce did. Mr. Bryce evaluated that opportunity, made a proposal to the board, and this is the key thing. As an officer, Delaware law makes clear, he's subject to the direction of the board. He has an obligation to comply with the board directors. And not only was that clear by common law, but it's also clear in the bylaws mandated that the German company maintained control over all the major business decisions of its subsidiary. And it was also in his limitation of authority agreement that he signed as the CEO. So he came to the board with a proposal. This is the strategy I'm proposing to try to bring this company back to profitability. The German board approved that strategy, directed him to proceed with it, and then throughout that process, he kept the board informed. There was actually a member of the board that was an engineer that he was instructed to have involved in it. He was in the testimony, the evidence was this was a hands-on employee. He was intimately involved in what was going on and trying to pursue this business strategy.
When you get a case like this, a summary judgment case, Mr. Fox is not trying to win the case today. He just wants to get back beyond summary judgment,
right,
which means there's an issue of fact in this case. So he sprouts out a number of facts that really are concerning, and that is, you know, you're setting up these contracts, you're not even ready for them, people telling you not to set up contracts, you're rushing through, you're not really prepared in doing it. Is that sufficient for, to create an issue of fact?
No, Your Honor, because again, courts aren't in a position, and that's why you have the business judgment rule. Courts aren't in a position to reevaluate risk. All of this is just merely risk. This is a situation where you've got the record evidence, the undisputed evidence, is that Shetler had coordinated with one of its major customers to make this design development, that there were these opportunities to get these Florida contracts to go deliver that product. And so, yes, you're taking a business risk because they want this product, the GMAX. They don't want the FS Uno. They don't want the other one. They're not going to buy it. So your opportunity here is to develop this and to get it done and deliver it. Those are business risks. And in order to get past the business judgment rule, you have to say that this is basically it's a gross negligence standard. Right?
Or that there's a conflict of interest.
Or that there's a conflict of interest. Correct, Your Honor.
So just to make sure that we close the loop, Mr. Fox referred to the Canada arrangement. So why does that not trigger at that?
It doesn't create a conflict. First of all, the Canada issue has nothing to do with the development of GMAX and these contracts. Okay, there's some allegations related to some transfers to Germany, to Shetler Canada. The problem is Shetler Canada is wholly owned by Shetler Germany, as is Shetler. And he's under the direction of the board to do these actions. So he's just merely following the directions of his parent in terms of how they're acquiring property or moving assets to Shetler Canada. That doesn't create a conflict. He doesn't benefit from that at all. And going back to the standard here, for the business judgment rule, which is basically outcome determinative, right? For potential, mostly, it has to be rationally inconceivable, right? That nobody would have taken this on. Nobody would have tried this. And the evidence on this is to the contrary. He had board approval to proceed with this. These people, everybody, this was a strategy they were all trying to pursue. So that's why the court was correct, both the district court and the bankruptcy court, in looking at the business judgment rule and saying they failed to overcome.
Well, having said all that, is it your position, I guess, that solvency doesn't play a role in this case?
It doesn't play a role because solvency was after the fact. But even if you accept something that's not in the record, which is the complaint, the BDO statement in the complaint, which is not evidence, right? That date is June 30th. As counsel conceded, it's after Mr. Bryce had left the company.
So my second question is, do you believe we have to determine that Shetler is a wholly owned German company or not?
I don't think you do in that sense. Now, I think it helps us in that reality.
If we don't, what rule do we apply? Because if it is wholly owned, it's the business judgment rule. If it's not, what is it?
No, and let me say, it is the business judgment rule. If it's wholly owned, it doesn't matter.
In either scenario?
It's the business judgment rule. What it does is it insulates Mr. Bryce, if it's wholly owned, it insulates Mr. Bryce from following the directions of its parent, advancing. So, for example, the allegation that he was paying the license fees. Shetler was paying license fees to the parent, okay? You can analyze that under the principle it's wholly owned, so if the Shetler Germany wants those fees, it's entitled to get those fees, and there's no breach of a duty. If it's not wholly owned, okay, and I don't know how it could not be wholly owned, because there's no other entity other than Shetler Germany that owns its stock. Nobody, the 5% sitting in the treasury is owned by no one. So there's only one owner, so totally owned. But that, even if you say, well, maybe the treasurer owns it, which is inconceivable, but it doesn't get rid of the business judgment rule. He's applying the business, he's doing what he thinks in the best interest of the company in paying these fees, maintaining the contractual relationship as they're developing this product. So I think that both business judgment rule would apply. Now, on the Caremark,
I'm sorry, Mr. Sims, before you go back to the Caremark claim, on this insolvency point, the BDO report, let's just, again, assume that we consider it, it's in the district court record, and begins with the date that postdates Mr. Bryce's departure. One of the appellant's arguments is, well, yes, that's what the BDO date was, and yes, let's assume there's not a zone of insolvency layer of the analysis, but one of their points is, a reasonable jury could infer from the BDO report that actually the company was insolvent sometime before that date. Why should we not accept that argument?
because they needed, at the summary judgment, they needed to put evidence in to establish that date, that it was, because, and it goes to the issue, right? If it's 3 days before he's terminated, then you would look at those 3 days to see, well, is there an issue in terms of what he was doing in those 3 days, right? If you go out 3 weeks, okay, so maybe you evaluate those 3 weeks. He needed to establish, the administrator had a duty at the summary judgment stage to come in and establish the point of insolvency.
But it's not like a time of death when someone, you have a date and it happens and all of a sudden you said you died on this date. When you made the determination of insolvency 3 days after, common sense tells you that company had something going on before then in order to get there. You build upon it to come to that. And the question that Judge Abramson, forgive me on pronunciation, Abramson, it said it goes to that, and that is, why couldn't a jury make a determination that, there is this exception here, but given the nature of the report, and when we go into it, maybe through discovery and all of it, and we decide, okay, this was already happening before then.
Well, the jury can't speculate. They can't speculate. There's no reasonable inference of when the point of insolvency is only the point that the creditors now, that the interests of the creditors are as part of the consideration. Okay? In the real world, most executives and boards don't know when they're crossing into that zone of insolvency. A lot of times that's a litigated after the fact situation to come back in and say, wait a minute, here was the point of insolvency, but here's the key thing. It's always a date. It's not a ephemeral, we're looking at this 3-month period. And this is what BDO did. They picked a date. And that is important under Delaware law because Delaware says until the point of insolvency, not the zone of insolvency, but the point of insolvency, the officers and directors owe a fiduciary duty to the shareholder only. And in this case, the wholly owned shareholders. That's who they owe a duty to.
And in fact, early in the case, I believe the administrator, maybe it was in the complaint, reserved the right to argue or come forward with evidence of an earlier insolvency date, but never did.
Never did, that's correct.
So let me go back and just make sure I'm with you. Insolvency doesn't matter, and that I think we can agree that allegations in the complaint don't rise to the level of evidence for a Rule 56 motion. What other evidence are you aware of in the record that would support their date claim, insolvency date claim?
I am unaware of any evidence in the record that would support a date of insolvency.
Earlier than the June date. Well,
Right.
if we consider the BDO report.
Exactly, Your Honor.
I see.
Exactly.
Was it a verified complaint?
No, Your Honor.
All right. You have anything further?
Do you want me to address the Caremark? I will just say this.
Judge, anything?
Okay.
Well, thank you very much.
Okay, thank you.
Mr. Fox, you have Reserve yourself an abundance of time, 2 minutes.
Thank you, Your Honor. I think I'd like to just address one other issue here, and that is, we had some discussion regarding, the appropriate standard to be applied here, and I think it's important to remember here that it wasn't just that Mr. Bryce was subject to the direction of the Board of Directors. Mr. Bryce has actually alleged that he was basically under the thumb of Schletter Germany and didn't really have the ability to act independently at all. And that actually calls into question what the appropriate standard is here for review. And I think it's important to mention a couple of cases here. First off, the In re MFW shareholders litigation, in which the court applied the entire fairness standard, where, quote, the fiduciary was, quote, beholden to the controlling party or so under the controller's influence that the fiduciary's discretion would be sterilized. Also, the Orman versus Cullinan case at 794 A. 2nd 5 at page 22, which is a Delaware Chancery case from 2002, in which the court stated that if the fiduciary, quote, lacked the independence to consider whether the transaction was in the best interest of the company and all of its shareholders.
Well, that's nice, but what's your evidence of that in the record at the time summary judgment was?
Our evidence, Your Honor, is Bryce's admission to that effect. Bryce has acknowledged that.
In this record, there's an admission from Mr. Bryce that he was under the thumb of his board and he had no discretion.
I don't believe he used the words under the thumb, but I believe that's actually been stated.
Well, what did he say?
I don't have the.
Well, you're asking me to accept that there's evidence that this guy couldn't perform his duties as the CEO of that company.
This is what has been alleged by Bryce in his briefing in the bankruptcy court, the district court, and I believe in this court as well, Your Honor.
Judge Wynn, could I ask one?
Of course, you may ask as many questions as you like.
Thank you. I'm trying to understand this under the thumb theory. Schletter US, let's assume, is a wholly owned subsidiary of Schletter Germany. As I read the Delaware cases, that meant that the CEO of the sub owed fiduciary duties to the parent. That's awfully close to taking the direction from and working for the benefit of the parent. So why does it breach the duties that Bryce had to take the direction from and do what the parent wanted him to do?
Well, Your Honor, first off, notwithstanding the fact that Bryce owed fiduciary duties to the parent, Delaware recognizes corporate separateness between a parent and a subsidiary. And so Bryce still had obligations to the subsidiary, notwithstanding the fact that it was a wholly owned subsidiary, and notwithstanding the fact that he had, pursuant to to the corporate bylaws, he had certain obligations to take direction from the board. I think the point is this goes a little further than taking direction from the board. Bryce has actually said it's more than that. It was basically, I read it as not having the ability to take any sort of independent actions that might even deviate from the direction given by the board, even if he thought that deviation would be in the best interest of the subsidiary. So that's where I'm trying to draw the distinction here. There's taking direction on one hand, and then there's absolute lack of any discretion on the other hand.
But do you agree that under Delaware law, the parent can direct the CEO of a subsidiary to close it down?
If it was determined that that would be in the best interest of the stakeholders, I suppose it could.
Okay.
Thank you, Your Honors.
All right, thank you very much both for your arguments. As is our tradition, we will come down to Greek Council. Our good colleague, Judge Floyd, has chosen to remain here, but his good feelings will be with you as we shake your hands down there. right, you may proceed, counsel.
Well, good morning, Your Honors, and may it please the court. At Keith Wood's first trial, defense counsel spent much of his opening statement cataloging inadmissible evidence from a forensic interview and therapy sessions with a child victim. Wood himself had successfully moved to exclude that evidence before trial. But once trial was underway, he candidly admitted that he had changed his mind about the value of that evidence to his case. So he tried to put it before the jury anyway. The trial court rightfully declared a mistrial after finding that no other viable option existed. A federal court refused to block a second trial. Wood was then retried and ultimately convicted, and the Supreme Court of Appeals of West Virginia affirmed. The district court here, however, set all that aside, finding that the state trial court should have said more and done more. But that decision fails to respect two separate and independent standards that ultimately dictate reversal here. First, under Arizona v. Washington, a trial court's mistrial determination commands special respect. And second, under AEDPA, a state court's rejection of a constitutional claim is entitled to extraordinary deference. The district court here, however, applied neither standard. Instead, it second-guessed state courts on questions of state evidentiary law, substituted its own judgment about the reading of pretrial orders, and ordered Wood's immediate release. All that was error, and the court should reverse. So I think there are really two important errors that the court can identify here that track the nature of the AEDPA standard. There's sort of the factual errors and the legal errors in which the district court approached this case. As to the factual errors, I think the district court did not appropriately determine that the state court rested its decision on an unreasonable factual finding. I think the AEDPA standards are very important here. Of course, AEDPA says that state court factual findings are presumed correct unless they are rebutted by clear and convincing evidence, and Wood must show that that determination was objectively unreasonable in light of the record.
So you're saying the federal courts can't even look at this because it's really a state court determination when it comes to the evidentiary aspect of it?
Exactly. When it comes to the application of state evidentiary law, exactly. That's even a higher standard because, of course, even in any case, even outside the AEDPA context, this court often defers to trial courts' readings of their own orders, but particularly when it comes to the application of state law, that is a question for state courts.
You would agree that it's clearly established that a trial court can't precipitately declare a mistrial just because the state gets flustered or is not ready to try the case. I mean, it seems, I understand the evidence was excluded. That's motion in limine type thing. Counsel made an argument. I don't know why it wasn't chewed out, but that's neither here nor there. But the mistrial gets granted. In the record, this evidence could have come in later in the trial anyway, by way of impeachment. And for the state to contend that this is just going to cause a disruption to their trial strategy, I'm a little, help me out, how to, if they knew this evidence out there and there is a possibility that it's going to come in impeachment or some other way, why was not that decision precipitately made by the trial judge?
Sure. I think there are two aspects in which this was obviously prejudicial to the state, even if one assumes that it actually could have come in through impeachment later, and obviously there are reasons why we would take issue with that characterization. But if you assume that it was going to come in later, the state didn't have the opportunity to address this in its own opening statement because, again, they knew that these pretrial orders were out there. They knew this was inadmissible evidence. So they were suddenly in the position of this important evidence. Really, the defense made this the centerpiece of their case, not being addressed by the prosecution at all. And so now the jury is left with the impression that the state is purposely hiding or at least failing to confront what the defense has just told. Sorry.
And you're probably right about that. But, you know, once the defense counsel opened the door, I'm assuming if the evidence was favorable to the state, they could uninvited error, done the same thing in their opening statement.
Well, so there's two aspects to this, Your Honor. Obviously, the state had already given its opening statement, so there's no way in which they could kind of go back and undo the fact that the jury is going to think they hid the ball in that evidence. That what's done is done when it comes to that. I think another part about this is, though, this record does not suggest that this evidence was all wholly favorable to the state or wholly favorable to the defendant. And the reality is that the state should have had the opportunity to prepare its case with an eye towards that evidence if defense counsel wanted to, in fact, introduce it. But instead, what defense counsel did was lead the state to believe that the evidence was not coming in. And so the state proceeded with preparing its case with that understanding. And then only at trial did suddenly we understand, now defense counsel, I think defense counsel candidly said, I got into this case and I understood that now this evidence actually favors me. And at that point, the prosecution in the midst of trial was faced with the task of pivoting their entire case strategy.
Let's talk about the standard of review. Would you agree that under Arizona, that we would be required to apply the strictest scrutiny to the basis for a mistrial if it's lack of prosecution preparation?
I think if that were the standard, that would be, or if that were the situation, yes, it would be a high standard. But let me make sure I'm clear about this. There are sort of several nesting layers of standards here. One, of course, is the Arizona v. Washington standard, and that's the sort of special respect for an error precipitated by defense counsel's prejudicial statements.
Correct.
You then have the abuse of neglect, or excuse me, the abuse of discretion standard that's applied by the state Supreme Court of Appeals. But then, of course, because we're on AEDPA review, now we're applying a reasonable application of clearly established Supreme Court precedent, and so that's sort of triply deferential. And so I think that's really where the state takes most issue with what the district court respectfully did here.
And the district court didn't, well, the magistrate judge applied the AEDPA standard, but the district court didn't.
Correct.
It was surprising to me that in the state's response to Mr. Wood's objections to the magistrate judge's report and recommendation, the state didn't argue AEDPA, didn't remind the district court that AEDPA applied.
So if my recollection isn't failing me, I believe we did cite the AEDPA standards. If we were less pointed than we should have been about the misapplication that Wood was inviting as to AEDPA, then shame on us. But I think it certainly wasn't a forfeited issue because we did tell the district court these are the standards that apply to an AEDPA case. And I think certainly your honors understand 2254s are some of the kind of most routine litigation that district courts confront for better or worse. And these courts well understand that extreme standards of deference apply, particularly when you're talking about factual findings, which is part of what was engaged here, and certainly when you're talking about an unreasonable application of Supreme Court precedent. And I think it really is notable that the only Supreme Court precedent that I think we continue to hear from Mr. Wood today is Arizona v. Washington, a case where the court is stressing the standard of deference, not suggesting that these are common errors, but suggesting just the opposite.
And the AEDPA, I'm sorry.
Go ahead. Please. Go ahead.
And the AEDPA standard in this context is that no fair-minded jurist would reach the conclusion that the trial court did. But here, the trial court found that there was manifest necessity. The West Virginia Supreme Court found that there was manifest necessity. The magistrate judge found there was manifest necessity. So that's the layer on top of the deference pursuant to Arizona that you're pointing to.
That's correct. And I would actually also slide in the decision on the 2241 before the second trial, where another magistrate judge and a district court who adopted that recommendation also said that the error was actually precipitated and the mistrial appropriately declared because of Woods' violation of the pretrial order. So I think if you're counting up, you've got 5, 2, 1. We're in the neighborhood of eight or nine judges now who have said it was an appropriate decision.
Well, I assure you that we are aware of the 2254 situation. We've had the Supreme Court comment on that. So
Certainly.
I'm aware of that deference issue. However, I'm not aware that manifest necessity is different in federal law as opposed to state law. If in this case, assuming there's no difference in the definition, are we bound by the by the West Virginia Supreme Court on its definition or application of manifest necessity here?
I wouldn't say you're bound, Your Honor, but of course your only question before you today is whether in applying that manifest necessity standard there was an unreasonable application of it. And I think what we've contended, of course, is that there's nothing in this record that suggests an unreasonable application of clearly established Supreme Court law. And I think Renico actually is a great example of this. That was a decision in which the Supreme Court was, again, looking at these double jeopardy standards, looking at Arizona v. Washington, and the Sixth Circuit had sort of chastised the Michigan highest court for not applying a sort of threefold standard that the Sixth Circuit conceived to constitute the manifest necessity standard. And Renico said, no, shame on you. The Michigan State Court applied the manifest necessity standard, even if they didn't apply it in exactly the same way as the Sixth Circuit had said it should. That's fine. As long as you're fundamentally reasonably applying that Supreme Court precedent, even if it doesn't track one for one with the particular circuit precedent that happens to be invoked, it's still okay. You still don't have to actually reverse. I think, unfortunately, that's what the district court did here. It took the Sloan language, which of course was a federal direct appeal, and applied this court's understanding of certain double jeopardy precedents from federal cases and effectively faulted the state court for not walking through that federal analysis. I think the Supreme Court just told us just recently that we have to be very careful about faulting a state court for failing to write more, to do a sort of bigger exposition of the relevant principles.
That's Klein you're referring to?
Exactly, but I think even Renico had already kind of established that before. I think it's also important that the state court is free to make its own assessments of the record before it. And as long as, again, those aren't clearly rebutted by clear and convincing evidence when it comes to the factual record, this court does owe deference to those determinations. So I think what you're seeing, Your Honors, is, again, this sort of two-part problem. There's the factual problem of its assessment of how things played out in trial. And I think another good example of that is its assessment that other alternatives weren't sufficient when the trial court did, in fact, walk through several of those alternatives before engaging with the question of a mistrial. The district court thought that there was a problem in the way that the trial court did that because those alternatives sort of weren't discussed again or discussed at length after the particular mention of a mistrial. But that's exactly the sort of deferential question, that the order in which alternatives have to be considered is the kind of question I think is exactly what EDPA has in mind. You owe some degree of deference to state courts. And so you have those factual questions, but then you also have the actual legal problem. And again, we think Arizona v. Washington, as the magistrate judge actually made a good point of saying, this really tracks Arizona v. Washington in a lot of ways, and we, I think, detail them in bullet points in our opening brief. You have a defense counsel standing up, making prejudicial statements that had sort of been expressly foreclosed even before trial started. You have the objections, you have the discussion of alternatives, you have all those same facts that the court saw in Arizona v. Washington and said, this is the sort of situation where we really have to defer to a trial court.
A couple other questions. Why did the state, and I think this is what I read in the record, why didn't the state object contemporaneously when the defense counsel went down that road rather than wait till the end of the argument and make an objection?
So I think in West Virginia, as in many places, there is a practice of raising objections after opening statement. I would note that in Arizona v. Washington, that actually was the circumstances there, that the objection was raised at the moment that, at the moment that opening statement finished, similarly. But again, that would be a question of state evidentiary law, state procedural law. The failure to preserve an objection is sort of a classic question of state law. And I think that the trial court found it sufficient to preserve the objection and in that way appropriately engage the issue of whether some remedy was required.
So in sum, your position is that we are bound by the factual findings of that state trial judge as to on the inability of the state to go forward based on lack of preparation.
Well, okay, so I think there are different standards of deference for different questions. I think when it comes to how state law, for instance, the requirements for a contemporaneous objection, how state evidentiary principles apply, those sorts of questions the court has said, really, this court is not in a position to second guess. When it comes to what the factual record shows, then EDPA gives us the standard, right? It's presumptively correct unless it's overcome by clear and convincing evidence, and it's an unreasonable finding based on a review of the record. And of course, when it comes to legal questions, then of course it's the question of contrary to or unreasonable application of clearly established Supreme Court precedent. So when it comes to whether there needed to be a contemporaneous objection, I think that falls into that first category. What is required under West Virginia law to sufficiently preserve an objection? Now, I do want to address one part of what Your Honor just said, which is a failure to prepare. I don't think that this is accurately characterized as a failure to prepare. I think that the cases that I'm familiar with where it characterizes it as a prosecutorial failure to prepare, for instance, is when there's a key prosecution witness that can't be located, and the state's saying, declare a mistrial because I can't get the witness here. And I think the Supreme Court has justifiably said, well, at least try a continuance. And if a continuance doesn't work, then really it's the state's responsibility to build its own case. So a defendant can't lose the right to have one trial just because the state can't get itself together in time to actually try its own case. This, again, is much different than that. The state was wholly prepared to try its case based on the rulings that were made by this trial court. And it was only when defense counsel decided to pivot away from that understanding, and again, I think if you read the transcripts of some of the pretrial hearings in this case, it was everyone's understanding, that it was at that moment that the state quite reasonably said, what? We weren't prepared to try the case as this. That sort of surprise is exactly the sort of thing that a pretrial order is meant to foreclose, and exactly the sort of thing that justifies a mistrial, and particularly when the prejudice is compounded by the fact that the jury is now going to be inclined to fault the prosecution for hiding the ball because they didn't actually address this in their own opening statement.
Well, counsel, but what about, for example, a curative instruction or even a supplemental opening statement, which would have been untraditional?
Right.
But, I agree with you that we have these, as you put it, nested layers of deference, but
Right.
still, why not a continuance? Why not a curative instruction? Why not a supplemental opening statement?
So I'm not familiar with any moment in which a West Virginia court has entertained a supplemental opening statement. I don't hear Wood actually identifying any of those. It's, as far as I know, does not exist, and that's probably why defense counsel didn't ask for it. A curative instruction, I think this court, and I see my time is expiring, but if I could just.
You can,
Thank you. As I think trial lawyers well understand, oftentimes curative instructions can compound the prejudice because they kind of hang a lantern on the problematic evidence. And I think especially so here because now you've got the trial court calling back to the jury's attention the problematic evidence without the prosecution having called that evidence out in the first instance. And again, I think that makes it look like the prosecution's trying to hide the ball in what has become all of a sudden the critical focus of this case. So the last thing I'll say on
curative instruction just about in every case, an opening statement is not evidence.
and of course
So you start out, if you mention something, there's no evidence been introduced in the case at all, other than a statement that you say you shouldn't have said anything about.
That is correct, Your Honor. The jury here would have been instructed as such. But I think Arizona v. Washington, among other precedents, recognizes that despite the fact that it's not evidence, that you can really poison the well by alluding to things and alluding to facts, especially when it comes to specific facts like this. I mean, this isn't just sort of a grand bit of rhetoric here. These are specific allegations about specific statements made by the key complainant.
You've teed us very well on your issue here. Let's hear what the counsel on the other side, Mr. Frankovich, has to say.
May it please the court. As our nation approaches the 250th anniversary of its founding, this case presents a question that goes to the core of what that anniversary represents. Not merely the passage of time, but
I always love an opening that starts like that. It's like, let's think about the world and where we are now, but.
I think it is important because what it goes to in this particular case, it goes to the constitutional framework that our country has endured over the last 250 years. One of the most fundamental of the protections afforded by the Constitution is the Fifth Amendment. The guarantee that no person shall be twice put in jeopardy for the same offense. That guarantee reflects a simple but profound principle that the state gets one fair chance of an opportunity to convict, and no more.
As soon as that jury is in panel, you put yourself in jeopardy, and that's the square issue before us today is that jury's been in panel.
That's correct.
You declare a mistrial, and you shouldn't have done one. In your view, that's double jeopardy, is what the district court judge held here.
And that's absolutely correct, Your Honor. And when the defendant objects to the mistrial, it requires a manifest necessity to overcome the double jeopardy hurdle.
Does it matter that it was the defendant that brought all this about? I mean, in many instances, the defendant might want there to be a mistrial. You open up with something like this, and you might not want to be tried then. You might want it in some of these cases.
Ultimately, I believe it does not matter that the defendant brought it. The question is still whether or not manifest necessity exists. I would also state in this case, the defendant did not bring this about, and I can get to that as to why why he did not violate the court's order. Even if we're going to accept for the deference that he did violate the court order, you still have to get to manifest necessity.
Of course, the threshold question is, can we even entertain this, and should we deal with the conclusions here of a state court? We're a federal court. State court has been through this, and how are we restrained in terms of the law that's before us, and what we can get into before we get into the thick of the weeds here.
Sure. I would think if this court cannot consider it, and the district court cannot consider it, there is no such thing as a writ of habeas corpus under 2254 anymore. There is a requirement of sound.
I don't mean it that broad way. You know the law on this. You know there is truly no such thing as the way it used to be.
Right.
You know what the Supreme Court has told us. It's told us that even we disagree with it, and we would rule something totally the other way. That's not the standard. It's a much higher standard than that. The question is this a case that meets that level of standard that we should find that this is just so unreasonable that it's not clearly established or whatever, or that it's clearly established otherwise, and the state court just didn't follow the law?
Yes, the court should find that, because what Arizona v. Washington requires is deference to the state court. But it's not deference to the state court's ultimate ruling. It is deference to the state court's exercise of sound discretion, which the trial court in this case did not exercise. It didn't apply the test in any way. It didn't determine that there was a high degree of necessity. It did not have any careful deliberation. I mean, the entire in-chambers discussion after a mistrial was, actually the judge in this case is the one who offered the mistrial. He asked, after there's a discussion as to what evidence was going to come in, the judge made the correct ruling initially. The judge said, you shouldn't have it. Well, let me back up. What the judge said was this evidence was admissible for impeachment purposes on cross-examination. The judge made that determination in chambers 6 times during the discussion. So the judge admitted that this evidence could come in. It would come in on cross-examination of the complaining witness, of the counselors. It was going to come in. So referencing it in the opening statement was not an error to begin with. So the high degree of necessity didn't exist to begin with. The court didn't even take that into consideration. But after the court makes the correct ruling that this evidence can come in for impeachment purposes, the state wants it in its case in chief. And that's what really happened in this case. The state didn't object when the reference was made. When they first come into the chambers, what the state does, it says, we wanted to discuss how this evidence could come back in. He complained that the defense opened the door, so we should get to use the evidence. That's what the state really wanted. It was only until the trial court said, does anybody want a mistrial? The state didn't even jump on that and says, absolutely, we need that. This was too prejudicial. We need a new trial. The state said, well, let us think about it. And then they come back, and then they say, yes, we would like a mistrial. And the reason for that was it was a strategic disadvantage. Strategic disadvantage is not manifest necessity.
Well, it can be. It depends what it is. It depends what the error is. And as I, perhaps sitting as a district judge reading this transcript, what appears to me is a situation where a judge made a pretrial ruling, defense counsel violated it, at least in the trial court's judgment, which we have to defer to at least on some level, and then was facing a situation where the jury had just heard this opening statement that was a very different opening statement than I think the government would have given if it had known that it could address this evidence in opening.
And I think one factual that keeps appearing is that the state did not address this evidence, because in fact, in his opening statement, the prosecution did reference the interview. They said the interview after the incident was reported, he does reference that the interview does exist. So I think the fact that, that it's not technically true, but besides the point, the state also, when we're arguing about a mistrial, right before the mistrial is declared, he said, we saw this coming. So when he admits, we saw this coming, this was going to be a problem, we didn't know how to deal with it. That is what the prosecution stated in the chamber's discussion. This was a lack of preparation issue. This wasn't an incurable necessity for this to be able to, that this evidence was never going to be coming in. They should have seen this. The state, actually, the prosecution admits, we recognize it is relevant. I mean, he does testify, or not testify, but he does state in the chambers, he said, we understand this evidence is relevant. If it was relevant, the state court said 6 times it is going to be admissible for cross-examination. The state should have known that this was coming. So if they didn't prepare.
But the judge issued multiple written orders that it was excluded, at least in certain circumstances, and it seems clear to me, reading the record, that the state understood that it should not be talking about what the victim said during those interviews. That's different than referring to the fact that an interview happened.
And I think that the orders that the state was precluded from using the evidence, it was very specific that the state was precluded from using those evidence. It never said anything about the defense. But I think regardless, even assuming that the state court's evidentiary rulings were correct, that's not the end of the inquiry. It's not about fault. And that's where the Supreme Court in this case made the mistake. The Supreme Court assigned fault. They said manifest necessity exists because defense counsel created it. That's not the scenario. That's not what Arizona versus Washington required. Arizona versus Washington requires sound discretion, and that sound discretion requires first determining whether or not it was truly necessary. And what truly necessary means there was not a less drastic means of proceeding with the trial. There could have been a curative instruction, as we've discussed. There could have been an opening or a supplemental opening. I mean, that would have been within the trial court's discretion to allow them to come back out I mean, there's nothing that prohibits that in the rule. Whether or not a case has done that in the past, it could have been done. A short continuance, which is what Arizona, and I think the state relies so much on Arizona versus Washington in saying that sound discretion is required. But in this case, what differentiates this case from Arizona was in Arizona, there were truly prejudicial statements. The defense made a reference to that there was evidence that was hidden by the prosecution in the first case. Truly prejudicial. There was no way to unring that bell. The court in that case also deliberated over 2 days to make a determination before deciding whether or not to declare a mistrial. It allowed the counsel to go home, do research on the issue of mistrial, and let him come back and argue the point. And then he also considered alternatives, and that was not done in this case. The discussion prior to the mistrial was about what evidence was going to come in and how it was going to come in. There was, once the court prompted the state to move for the mistrial, there was no discussion at all. The state, or the defense counsel actually strenuously objected to the mistrial and said, I will stipulate that all the evidence comes in for all purposes in the state's case in chief, which is exactly what the state asked for at the beginning of this discussion. Let the evidence in. And the defense said, it is so important that this case proceed before this jury at this time, I will concede. I'll withdraw all of my motions. I'll let the evidence come in. That was the cure. The court did not consider that.
From the defense perspective, but the government and the state and the court did not see that as sufficient. The harm was done.
The state did see that as sufficiently because that's what they initially asked for. The state initially said, he opened the door, this evidence should come in. It was only after they were given the opportunity by the trial court to consider a mistrial did they think it over and say, yes, we want to redo. We want to better prepare. After this, before the new trial, they filed 7 motions in limine that they didn't file the first time. They were able to better prepare, and that's what the double jeopardy is designed to prevent. It is designed to prevent the state from getting a second chance when manifest necessity doesn't exist. Because it puts the defendant at a huge disadvantage. This was a case where the state was unprepared, admittedly unprepared, because they said, we have thought about this for weeks and we didn't know how to address it. That right there, that argument that this was anything other than a strategic or a lack of preparation is out the window because they admit it.
Could you address the AEDPA standard?
I can. The requirement in that issue, or in the AEDPA standard, is that it is an unreasonable application of federal law. And that's exactly what happened here. Federal law requires sound discretion. That was not done. There was no consideration of alternatives. The state court acted precipitately. It was within minutes of the state or the trial court offering the mistrial to him declaring one. There was no discussion of alternatives. And I think one of the core cases recently that came out from the Supreme Court is Klein v. Martin, which I think is really telling and really important in this case. And
Right, it said we have to consider whether any fair-minded jurist would do what the trial court judge did here.
I agree, and I don't think any fair-minded jurist would in this instance, because what Klein said was the state applied the correct rule. It cited the right case law. And the district court or the federal court decided, no, you should have analyzed it a little differently. You should have been more nuanced in your discussion. There should have been more back and forth. But the ultimate holding in Klein was that the state applied the right rule, and we need to defer to them when they're applying the right rule. We're not going to impose upon them on opinion writing standards. In this case, the West Virginia Supreme Court did not apply the right rule. They applied a fault-based rule. They said, I mean, the entire opinion by the West Virginia Supreme Court is one paragraph. And what that paragraph says is, here, petitioner's right against double jeopardy was not violated because at his first trial, his counsel created a manifest necessity for the mistrial during his opening statement when he repeatedly referenced evidence that the trial court had clearly ruled inadmissible. That was it. That was the entire decision by the West Virginia Supreme Court.
Well, but it was citing Keller, its earlier opinion, which was itself relying on Arizona. It was applying the Supreme Court's Arizona versus Washington standard.
Well, they were applying Keller, but when you read what they're citing to in Keller, it says, this is particularly true in cases where it says, the term manifest necessity covers a broad spectrum of situations in which some instances bear little relationship to the literal meaning of this phrase. This is particularly true in cases where the conduct of one party at trial has created sufficient jury prejudice toward the other that is unfair to continue with the trial, and mistrial is warranted. There was no discussion of what Arizona actually requires. Arizona actually requires consideration of alternatives. I mean, in the other cases of this court that actually show where sound discretion was applied was in a case like in Sloan, I think is a really good case where the Fourth Circuit held that sound discretion or manifest necessity requires a scrupulous exercise of judicial discretion that leads to the conclusion that the ends of public justice would not be served by continuation of the proceedings. And that sort of sound discretion did not happen here at the trial court. This isn't a second guessing of how the trial court or even of the West Virginia Supreme Court wrote their opinion. The fact is that they did not apply the right standard, the standard that manifest necessity exists, and that they basically totally assign fault in this case.
How do you address the fact that the trial judge in ruling said, quote, I have to declare a mistrial, which pains me. So that's what the trial court said, and then the West Virginia Supreme Court cited Keller, which was applying the Arizona standard. That sounds an awful lot like applying the right legal standard. You may have disagreed with it, but then when we apply, because then you go to Sloan, but that was a direct appeal. So not only does it seem to me that the trial court understood that it had to be really necessary, and then the Supreme Court of West Virginia applied the Supreme Court standard, and then now we have to decide whether no fair-minded jurist would agree.
So the trial court in this instance, I think it's telling that it was not necessary because he's the one that prompted it. He made the correct ruling. This was an evidentiary issue. It was not a constitutional emergency. What happened was they're talking about how the evidence is going to be introduced. And he said 6 times, he says, it is admissible on cross-examination. He finally comes to the conclusion that says, but defense counsel, if you use it on cross-examination, you are going to open up the door and that evidence is going to come in its entirety. And defense counsel says, fine, I agree. The very next paragraph, the prosecution responds by saying, well, how is he going to get it introduced when he's going to need somebody to authenticate this interview record? And at that point, there's no discussion about the mistrial. We're talking about an evidentiary issue as to how the evidence is going to come in. The trial court says, do any parties wish to put forth a motion for a mistrial? He prompted it. That is not the exercise of sound discretion. He prompted the issue because he didn't want to stick to his ruling as to how the evidence was going to come in because he continued to get pressed by the state so they could use it in his case in chief, which is actually what the defense counsel ultimately conceded. Go ahead, use it in your case in chief. This needs to be decided today. That was the issue. So I don't think that the trial court, he made the statement after he declared a mistrial because he was trying to cover for the lack of the sound discretion that was not done. He just, at the end of it, he says, it pains me to do this. Yes, I need to, but that's not reflected in the actual discussion in the chambers. It wasn't necessary because what the state wanted was granted to them.
All right,
What-
you have something further?
Let me ask you one more question. What do we make, from your perspective, of the fact that the district judge did not apply the EDPA layer of the analysis? You're asking us to affirm, but that analysis was not done. So are you suggesting that we should do that in the first instance and then reverse?
The district court below, I do believe, applied the EPA standard. It stated exactly what was required to grant the 2254 writ. So I believe that the district court did apply the correct standard and cited the correct law and determined that manifest necessity did not exist in this case. So I do think the district court was correct in applying the correct standard and found that no reasonable jurist could have come to the conclusion that the trial court, and in this case the Supreme Court, would just rubber stamped it without any analysis at all.
To get to that point, we have really got to buy into the fact that the trial court precipitously declared the mistrial.
That's one element of the standard. I believe the failure to consider, and he did do that, but I think you also can show that the district court did, or the trial court did not consider alternatives. It did not give any consideration to the defense counsel or the defendant's right to have the impaneled jury make the determination. The defense counsel was strenuously arguing and conceded in all respects, let the evidence come in. We want this to be the jury.
The chamber's discussions are in the record.
They are, and it's pretty brief, and I think that kind of goes to, it's about 20 pages of transcript. It is not a very long discussion because it reinforces the fact that the trial court didn't put much effort into making this determination. It was looking for, it was faced with a difficult evidentiary decision, which I think is true, but that's not manifest necessity. I think that the court at this point decided that it was going to have to make a tough ruling and decided that it would be easier to declare a mistrial and address this at a later time, when a continuance could have done that, which was a reasonable alternative in addition to the curative statement, in addition to allowing all the evidence to come in, which is what both of the actual parties agreed to. So I do believe that manifest necessity under Arizona versus Washington in the U.S. Supreme Court did not exist in this case, and I don't think there's anything in the record that supports that there was.
Thank you for your arguments, Mr.
Thank you.
Falk. Mr. Frankovich, did I pronounce that correctly?
Frankovich?
Yes. Mr. Williams, you have 3 minutes.
My name's a little bit easier. So I think we just started that discussion with a discussion of the framework, and I think it's important to go back again and think about the relevant framework here, and that framework is EDPA. I think at bottom what EDPA
Did the
asks...
trial court apply the standard here?
I don't see that, Your Honor. And I think what the trial court did is I think felt that this was a mistaken decision and acted accordingly. And that is simply not the relevant standard when it comes to EDPA.
Then answer Judge Abramson's question on that was directed to the possibility they did not apply it. What do we do if it wasn't applied?
Well, I think Your Honors, of course, have to apply the EDPA standard. That's the relevant standard that applies here. And I think that...
Do we send it back for the trial court to do it, or do we do it?
I think because it's a question of law, it would be most appropriate for this court to address that issue. A remand is the minimum baseline for what this court needs to do in a case where the court doesn't apply the EDPA standard. But I think given that it's a question of law, that's the straightforward issue for this court. I think in listening to Mr. Wood's counsel's argument, I think even today, we're still not seeing the degree of deference that this court has to engage with when it looks at this record. We see things like guessing at the reason why the trial court declared the mistrial, that he just didn't want to deal with what the consequences of his own evidentiary decisions. Respectfully, that's not in this record. And the suggestion that, for instance, There was no discussion of alternatives. Again, respectfully, that's not in this record. There's an attempt to draw an arbitrary line between the first mention of the mistrial before and after, but all those alternatives were discussed before the mistrial was ever raised, and that still counts for purposes of Arizona v. Washington. I think there was a suggestion that the trial court itself thought all this evidence was admissible. I would just direct your honors to JA 111 to 112. Sir, you can't simply move to exclude evidence of the interview, which I'm absolutely certain should be excluded under Petrie, and then go ahead and start alluding to statements made in that interview. And then with regard to Ms. Aspenleiter, we have the same problem again, sir. This trial court was unequivocal about this was inadmissible evidence. And things can happen at trial that, yes, open the door to impeachment evidence. But that was at this point in time, a speculative possibility that, to be clear, still would not allow this evidence to be used as substantive evidence, which is the way in which this is being used in opening statements.
You say that the alternatives were discussed in chambers. Could you?
Yes, Your Honor.
Could you tell me a couple of the alternatives he considered?
Sure. Well, I think there was a discussion of a potential curative instruction, but the court thought the bell had been rung, it was too late for a curative instruction. There was a discussion of potentially just introducing all of the evidence and allowing sort of a free-for-all when it came to all of that evidence. But again, there were reasons why both the state and initially at least defense counsel, until he saw what he had done, both didn't want that. So those were two that come immediately to mind. And I think those were the two that were sort of most readily available under West Virginia law. This sort of supplemental opening statement, again, I think would be kind of a novel approach. But ultimately,
Well, you could have done it. Once you get to a situation like that, trial judges got almost absolute discretion to level the trail.
so
And I've done that before. I mean, I know
I'm not sure that West Virginia law gives a state court trial judge that much discretion. And again, that's the kind of state law question that this court is not in a position to address in the first instance. All I know is, of course, what the law says, and I've never seen a case that endorses that sort of kind of ad hoc approach. Ultimately, I think what I heard from the district court judge and what I heard again today is frustration with the trial court judge and to some degree the Supreme Court of Appeals and the way in which the analysis was written or described. Cases like Harrington make it very clear that the length or the comprehensiveness or whatever of the analysis is not the relevant question. The only relevant question is whether they were inconsistent with clearly established Supreme Court precedent. And given that we have the manifest necessity standard applied here, the court simply cannot find that
Thank
to
you,
be the
Mr.
case.
Williams.
Thank you.
very much. You want to take a break?
Yeah, if you want.
I know it's on you.
Yeah,
You want to take a break or just get up to you? Springs Custom Homes versus Argos Group. You may proceed.
May it please the court, George Sideropoulos for appellant Bristol Springs Custom Homes. Bristol Springs, a Martinsburg business, bought insurance for exactly the situation that unfolded. A jury entered a $325,000 negligence verdict against it. Its insurance company's response to the verdict was another lowball offer, this time $125,000. Thereafter, it threatened a declaratory judgment action to avoid coverage entirely. and stood by with its hands in its pockets while Bristol Springs went bankrupt. Ultimately, Colony Insurance Company paid the verdict, plus interest, but only after Bristol Springs filed the incident lawsuit alleging breach of contract, what's colloquially referred to as common law bad faith, and a statutory cause of action for unfair claim settlement practices that rise to the level of a general business practice, a UTPA bad faith case. The district court nonetheless held that Bristol Springs attorneys were not necessary to achieve the settlement. That conclusion is wrong as a matter of West Virginia law, and we request that the court reverse. I will argue two issues. First, that Bristol Springs substantially prevailed on indemnification and is entitled to hayseeds damages, again, what is sometimes colloquially referred to as common law bad faith. Second, that Bristol Springs had standing to assert a statutory bad faith cause of action under the West Virginia UTPA. Thereafter, I will respond to the appellee's cross appeal regarding certifying this issue to the West Virginia Supreme Court.
Well, we call it Tiger River in South Carolina, but you call it hayseeds in West Virginia. There's no law allowing a hayseeds action against a third party, is there?
I think there is, Your Honor.
Is there a West Virginia case that holds that? Because the problem with that, allowing that kind of stuff, and I was a plaintiff's lawyer, by the way, is foreseeability, and which is the key to the hayseeds and Tiger River and all those cases.
Yes, Your Honor, I think this ties into the Stuckey and Salango opinions that address the UTPA provision kind of elegantly. In one sense, you cannot get hayseeds damages for getting your case settled when there's a disagreement about trying to get your case settled as a civil defendant. But once a judgment order has been entered and you make a claim, it's now a loss claim. It's no longer a situation where it is a third-party claim. It is a first-party claim for indemnity under your, in this case, commercial general liability policy. And I think that is explicit in both Stuckey and Salango, that emphasizes there was no judgment order entered in those cases, and that this court has also addressed that very issue in Graham to some extent by parsing out what it means to be a first-party claimant, a third-party claimant, and a first-party policy and a third-party policy. I hope that addressed the court's concern in that regard. The district court in this case held as a matter of law that
Tell us
Bristol...
about the counterclaim here. You had a counterclaim, and some question as to whether, you can have relief in your instance if you have a counterclaim, you haven't released it. You can't get anything approved until it's over, can you?
You would simply pay the verdict amount. That would discharge all liability. The novel argument that's made by the appellees that somehow the underlying defendants having a counterclaim would extinguish the obligation of Colony Insurance Company to indemnify their policyholder for a judgment is novel, but it's certainly not persuasive. In other words, if the insurance companies wanted to pay a compromise amount, they could, certainly try to negotiate that with a underlying defendant who may have concerns about the coverage issue. But that wasn't the case here.
Even if they were going to pay the full amount, the insurance company's not going to write the check without a full and complete release of all claims. And isn't it your counterclaim that held up this thing?
Well, so it would satisfy the judgment order.
No. Well, that may be true, but ending this litigation, it won't. If you got a counterclaim hanging out there.
Because it would satisfy the judgment, there would be no need for a release.
Would you have signed a release?
In other words, would I as the insurance company or would I as the underlying defendant?
On the counterclaim, would you have signed a release waiving the counterclaim?
So in this case, underlying defense counsel absolutely offered to waive the counterclaim. Leanna Stinson did that. That's in the record, and that was done following the judgment, following the verdict, before bankruptcy.
I thought you had a counterclaim.
We did it.
Well, my question is, would you have released it?
Yes, and in fact.
Well, why didn't you do it?
So it was offered as part of the first kind of settlement offer by our client in the underlying litigation.
Where is it in the record that you agreed to drop your counterclaim?
Let me see if I can find you the, it
I
is in
mean, I
fact.
may be reading the record wrong. If I am, I apologize, but it seems to me, my recollection of the record is, you wouldn't let go of that counterclaim, and it couldn't get settled because of that.
Yeah, so I'm clearly not doing a good enough job of explaining this. It's certainly not the court's fault. Yes, the underlying defendant, Bristol Springs, offered to release its counterclaim. At that time, the insurance company only offered to pay $150,000 to settle the judgment. This is post-underlying trial. Then, because that obviously wasn't going to get the job done, because they wouldn't pay the entire verdict, Bristol Springs is forced into bankruptcy. They couldn't get credit. They couldn't afford their bills. At that point, the right to the counterclaim is now owned by the bankruptcy trustee. It's no longer owned by the underlying defendant, and I think that may be where the confusion of the court is. But I think that that's really a red herring. I don't know that the court needs to get to the issue of the counterclaim, because to the extent that the insurance company pays the verdict amount, the counterclaim can operate independently as a claim, and there's no longer any sort of liability for the judgment that's been entered against Bristol Springs, period.
Counsel, you say if the insurer just, quote, paid the verdict, but the cases, including the Haydorn case, for example, from the Supreme Court, said, I think the line is, it takes two to negotiate. And as I read the record, the only monetary demand or offer, depending on how you look at it, prior to the lawsuit was for $391,000. And then you say, well, the next thing we had to do, we had to sue. So it seems to me that under the Hayseeds analysis, there are a couple of components that require a showing of necessity. One is that the insured take reasonable steps to try to settle without filing suit. Otherwise, how do you show necessity? The next is that essentially, despite those attempts, the insurer completely refuses. And that third, but for the litigation, there would not have been a settlement. But here, the colony was offering money. It was kept increasing its offer. It was up to $150,000. You had only made a full, no compromise demand. How does that put you in Hayseeds territory?
Yeah, so in order to prevail on a Hayseeds claim, a plaintiff does not need to show bad faith on the part of the insurance company.
I didn't
Only
say
that
bad
a
faith.
demand for the policy proceeds or a demand for some amount was made, and that thereafter they have substantially prevailed when the insurance company offers less than that amount. And this really is an elegant solution by the West Virginia Supreme Court because it prevents a situation where an insurance company can make lowball offers and say, you know, well, we offered something, and then a policyholder has to incur the cost and expense of protracted litigation in order to get the benefit of the bargain. So here, Colony and Argo had all the time in the world to try to get the claim resolved for any amount of money that they possibly wanted to prior to the judgment entry.
But the
So
question is going to but-for causation, as I understand it. And you've got an instance, as the judge has pointed out, in which you've got the insurer making some efforts toward negotiating before this lawsuit is filed, making efforts of going back and forth on it quite a bit. And then even you, in your litigation posture, you have a counterclaim out there. And so you got efforts are being made. Where's the but-for causation that a jury could come out of that with?
Yeah, thank you for the opportunity to address that. Colony and Argo have indicated throughout the litigation that there was very little coverage in this case. The coverage analysis that they did indicated there was only coverage for broken windows. That's reaffirmed in a conversation by Don Larson, who was the adjuster for Colony, with underlying counsel for Bristol Springs, Leanna Stinson, and that's in the record and in the underlying briefs. That there's just not a lot of, and I forget the turn of phrase that she used, indemnity here, but essentially that we Argo and Colony don't have a lot of exposure. You guys are going to have to figure it out on your own, which is why the referral is made to bankruptcy counsel, because obviously Bristol Springs didn't have the cash on hand or the liquidity to satisfy the judgment. And that's what compels the complaint for breach of contract, alleging that in fact there was a fatal error that was being made by Colony and Argo, which is they didn't appreciate that under the Charrington case, this was a covered claim. And that's really the answer to the but-for question.
But by the time you sued, they had already put $150,000 on the table.
Yes, which was contrary to what they had said in less than half of the verdict amount. And I really think was just kind of an effort to say, we'll wrap this up.
But so then, on this record, you necessarily have, it seems to me your position necessarily has to be that Colony had to negotiate against itself. It had to make multiple moves in a row. You didn't counter the 150 before you sued.
I mean, I wasn't I don't have to. I'm not the underlying plaintiff. And what we really wanted was indemnity. When Argo and Colony say, we're going to gamble by not paying the judgment amount because we don't think that it's actually a covered loss, and lose.
But you don't think they offered $125,000, $150,000 for some broken windows?
There's no explanation for why. I mean, I dare not even speculate how much it must have cost to put on a trial, what the appeal would cost, and what they were paying their lawyers. And if they really thought they were going to win on an appeal, they'd have to try the thing again. I think they were just trying to get out. And they knew that there was a bankruptcy attorney that was here and potentially new counsel, coverage counsel, that may come in, which in fact was the situation.
You have substantial time you've reserved for rebuttal, so we'll hear you when you come back.
Thank you so much.
All right, you may proceed.
Good morning, may it please the court. Jack Ryder and Matt Perry on behalf of Argo Group and Colony Insurance Company. I'll start off by talking about our argument with respect to the appeal with respect to why the judge was correct, if the Hayseeds doctrine applied at all, in the conclusion that the judge reached. First of all, Judge Wynn, as you pointed out, it is a but-for analysis. And the bottom line is that in order to establish entitlement under Hayseeds doctrine, it is very well established that there was a requirement that that Bristol demonstrate a but-for causation, that the retention of counsel was necessary to obtain resolution. And as several of you pointed out during my opposing counsel's presentation, the settlement negotiations were forthcoming by Colony immediately after the verdict came in. And this is reflected not only by the testimony in the record, but there are abundant claim notes that are part of the record, JA 1012, where shortly, the day after the verdict, there's internal notes memorializing the fact that Ms. Larson, on behalf of Colony, talked to the insured about getting this back to mediation. At JA 1013, there's continuing correspondence, or excuse me, JA 1011, where this is October 24th, just days after the verdict, reflections of Ms. Larson's communications with plaintiff's counsel and discussions to, quote, determine a plan for resolving. Meanwhile, the parties were actively working on a post-trial motion. There was no risk of any sort of execution because everybody understood that because the post-trial motion was being prepared and would be filed timely, that there would be a stay of any sort of execution efforts.
Let me ask you this. You got a judgment of $325,000. You offer $125,000, $150,000. I mean, you got to believe with that differential there, Bristol is gonna owe some money if you only pay that amount of money for it. I mean, they have a right to fear that they're gonna end up owing a lot of money for this thing when they have insurance.
Understood, but there were ongoing negotiations. This wasn't a hard stop.
And the
It
basis
wasn't-
being that you didn't think you owed the full amount, the coverage thing that, you heard what he said in terms
Sure.
of broken windows. They were a little bit more than broken windows, obviously, because of the $125,000 you owed, but it must have been some coverage question here that would prompt you to offer a lowball offer on a $325,000 judgment.
So first of all, Your Honor, there were certainly coverage questions, which is why Colony defended under a reservation of rights and defended the
Now,
insured.
procedurally, these questions, I'm trying to think, seems like to me when you have that, you have a declaratory judgment or something, some type of declaratory action on the part of the insurance company that says, no, we don't defend, we don't cover, get all those questions here. And it sounds like we're at the end of the case, and now the insurance company says, no, I'm not paying that, I want to negotiate this judgment that Bristol got a judgment, $325,000. So the question, then they say they got to get counsel to get you to do it. And of course, that's the question. The question is,
Sure.
does the lawsuit make you pay this amount of money? In other words, they had to get a lawyer to do this, and then you pony it up then.
And the facts don't support that conclusion, Your Honor. The undisputed material flat facts, and it's unequivocal. The timeline is clear. The timeline makes very clear that Colony, the day after the verdict, or within days after the verdict, immediately stepped up to the plate. I would respectfully submit that $150,000 on a $300-something thousand verdict is certainly not a paltry sum. It's a starting point for
It
negotiations.
is if you're on the hook for the $175,000 difference it is, whatever the difference is on it.
And again, Your Honor, understood, but there was, the question is the but-for. And as Your Honor pointed out, and Judge Floyd, I think you also pointed out, the fact is there was a counterclaim that held up the resolution. And again, the testimony, the timeline, and the evidence, undisputed, establishes that there were communications where Colony said to Bristol's counsel, and there were communications with defense counsel, communications with personal counsel, before bankruptcy counsel was even hired. Okay, we heard a lot from counsel, and we saw this in the brief, and a lot of argument below was this notion that somehow Bristol had no choice but to file bankruptcy. But the bottom line is that the negotiations were ongoing, number one, before bankruptcy counsel was even retained. Number two, there was discussions about withdrawing the counterclaim before bankruptcy counsel was even retained. And there was also the notion, understood and undisputed, that the post-trial motion stayed execution. So the concerns that I've heard expressed simply were not supported by this record. Understand, again, negotiations are negotiations, and those were going forward before the bankruptcy counsel was even retained.
And it really comes down to a question of, I guess if you've done nothing, that's one thing, but the picture is, well, where does it become essentially nothing or not much? Yeah, you did some negotiating, but if you offer $125,000 off of a $325,000 verdict, and you call that negotiating, and I guess, I don't know the incentive to negotiate. Who are you negotiating with?
I think, Your Honor, the best way to answer that question is to juxtapose this case with the Bailey case, which,
Who are you negotiating with?
at what point, Your Honor?
On $125,000?
Well, the negotiations were ongoing. There was communications.
With whom?
With the plaintiff's counsel,
Yes.
directly with, and this was all communicated with
And why
personal
would
counsel.
plaintiff counsel take that with a $325,000 verdict when it's got a company there and an insurance company?
And again,
What would move them to take $125,000? Judge Floyd said he did a little plaintiff work, I did it too, but I'm trying to figure that one out. Who is gonna take that as a plaintiff counsel if I got a company sitting on the other side with a $325,000 verdict with pre and post judgment interest on tacked to it, and you come along as the insurance company and says, I'm gonna negotiate this to 125, where is that incentive to even take it?
Your Honor, when money's on the table and post-trial motions are pending and an appeal may be coming, as there was going to be.
But money on the table
incentive-
is the key, and Lord knows I had enough judgments on the wall that never got paid, but when I got an insurance company on the other side, something's gonna be paid. and an insurance company. I'm just trying to,
Sure.
I'm just trying to understand what's the negotiation with the plaintiff's lawyer on this thing?
I understand the court's point. I want to
But what's the
juxtapose.
answer, is
Because
what I got the point, we both got the point. What's the answer to that? Because it's confusing to me, and it may be plain as to what was going on here, but I can't understand it. As a plaintiff's lawyer, unless you felt like Bristol couldn't pay you anything, or didn't have any assets on this thing, you can get that judgment some kind of way, whether you're gonna own a company or something at the end as a plaintiff's lawyer. There's no way in the world I'd take $125,000 on $300,000, $25,000 verdict with a company. Now, if it was a guy on the street that had nothing, oh yeah, I think we could talk a little bit.
Your Honor, I hear Your Honor. The point I'll make in response is that the record reflects that at all times, the plaintiffs were willing to take less. What that less was a matter of open negotiation, and that's reflected by the record.
On the
Let me turn.
hayseeds issue, not necessarily me, but folks in my chambers have looked at hayseed cases, and in every one of them, they talk about first-party claims. Would it be reasonable for us to predict that the West Virginia Supreme Court would not extend a hayseed's claim to a third party?
I thank you, Your Honor. I'll turn to our cross appeal then, since with that question, and I'll rest on my brief for the statutory issue and the standing issue unless there's any questions about that, because I'm running low on my time. So let me turn to the cross appeal. Your Honor, I absolutely believe that this court can determine that the Supreme Court, or it could certify the question, but I believe this court can determine, based on the unbroken line of authority, that the West Virginia Supreme Court would in fact conclude that the hayseeds doctrine does not apply to third-party insurance claims like this one. And Your Honor started off at one point by asking my opposing counsel that question, and I think that if we look at the history and the sort of the development of the hayseeds doctrine, it's always been a first-party principle. The hayseeds case itself was limited to property damage cases, talking about when a policyholder substantially prevails in a property damage suit against its insurer. And when we look at the history or the evolution of these cases, Marshall versus Sassine, uninsured motorist cases, Miller versus Fluharty, again, uninsured motorist, first-party claims, Haydorn versus Shea, LeMasters versus Nationwide, talk about the fact that when we're dealing with the hayseeds doctrine and that principle, it necessarily is it is a first-party principle and not a third-party claim. And there's really no reason that one would extend the hayseed damages, the hayseed principle, to a third-party claim, because there are other mechanisms that exist for purposes of allowing a sort of, I guess you'd call it a fee shifting or an award in a third-party context. You know, so for example, and let me also let me take a step back for a moment and just address the point that, you know, the idea of the concept of the substantially prevailing test, sort of the driving test that dictates how you analyze the hayseeds doctrine. The concept of substantially prevailing doesn't fit into the contours of a third-party case. When one has even that threshold question, right, when one says in examining hayseeds, did the insured substantially prevail in their pursuit against the insurer in pursuit of retaining funds, and was an attorney necessary to get there, that doesn't fit into the contours of a third-party case. And similarly, when we examine sort of the test for what constitutes substantial prevailing, you know, the amount of damages recovered by an insured juxtaposed with the amount originally offered, whether it's through a verdict or through a settlement, once again, does not fit within the contours of the hayseeds doctrine, which is really necessarily a first-party principle.
And how do you square that with the chronology here, where the offer on the table was $150, lawsuit was filed, offer jumped to at or near the verdict?
So, and just to make sure I'm asking this correctly, you're talking about this in the context of the cross appeal or the principal appeal, or both? Because I want to.
Well, from the insured's perspective, as I read the cases under hayseeds, the context is to protect insureds and to prevent an insurer from stringing along an insured in ways that causes harm to the insured.
Okay. So just to make sure that I'm answering Your Honor's question, the kind of colloquy and the back and forth here was a third-party scenario, not a first-party scenario. So if we, again, we step back from what I consider to be the application of the hayseeds doctrine, if in this case.
Yes, you need to do that because you said certify it. Well, we certify it and the court comes back and say it is. You don't want to say that's the end of this case. You want us to go back now and look at the question that the judge just posed here.
What I would ask for in this case is that the court would theoretically reverse and remand for entry of judgment in favor of Colony and Argo on the fact that the hayseeds doctrine doesn't apply at all. And there is no, in other words, this is not a circumstance where there's a basis for extra damages because it's a third-party scenario. At the third-party scenario, this is, and to be clear, this is a circumstance where Bristol was never left undefended. And so this is kind of switching back to when you examine what are the protections in a third-party context. They were always defended, never left to their own devices, never exposed to an excess judgment. In fact, to the contrary, the amount of the demands were always below policy limits, so they were never in a circumstance where they would have been exposed to an excess judgment. In a third-party context, which is what this is, had they been exposed to an excess judgment, there are alternative remedies available under law that exist that specifically provide the framework for recovery, that hayseeds fills the gap for the first-party claims, and the common law bases for recovery fill the gaps on third-party claims if an insured is subjected to an excess judgment or is left undefended,
Well,
which didn't happen here.
Let's
Yes,
go
Judge
back to
Floyd.
what you want. I think we normally operate under the theory that we decide only what we necessarily have to decide.
That is correct.
The only reason we would have to get to the hayseeds third party is if we were to reverse the trial judge on the renewed judgment for hayseeds damage.
That is, I agree with that, Your Honor. Procedurally, if this court concludes that the district judge was correct, then technically it does not reach the cross appeal. And that is accurate, Judge Floyd.
And we wouldn't have to predict.
That is also correct, Your Honor. That is correct. Now, certainly, this court always has the authority, if it finds the question one that is sufficiently indicative of needing of clarity, the court still has the authority to certify it. But of course, I agree, Judge Floyd, that if the court concludes that you affirm on the principal appeal, then the court does not reach the cross
Well, my
appeal.
question, follow-up to, do you really want a certified question?
Your Honor, what we're here today is to ask the court to affirm. And ultimately, if the court should affirm, then we understand that that would be a sufficient relief for what we seek. The cross appeal is, of course, a backstop if the court were to determine that for any reason it were to not agree on the principal appeal. I respectfully submit that here the court can and should affirm, and I understand also that that would eliminate procedurally the court's need to go forward. Now, I'm into what would be my rebuttal time on the cross appeal, but I will ask before I sit down, if I may, are there any questions the court has as to the principal appeal, either as it pertains to the hayseeds issue or the statute, which I didn't really address as the standing issue, which I didn't address as vigorously.
Sure, just one to go back to that. So
Yes, Your Honor.
With thinking about the but-for
Yes.
standard, here, chronologically, Bristol filed the lawsuit November 13th, 2023. Within weeks, 6 weeks, or I take that back, within 2 months, the offer on the table jumped from 150 to 250, and then within 5 or 6 weeks after that, the offer jumped to 385. Just chronologically, if we're thinking about but-for cause in a general tort context, it appears that just based on that chronology, a reasonable jury could find that it was the lawsuit that triggered the increase. Now, that doesn't, I think, answer the question about from a hayseeds perspective because of the questions I was asking Mr. Sideropoulos.
Sure.
But I think you're saying that no reasonable jury could find that the lawsuit spurred the increase of offers.
That's correct, Your Honor, and I'll respectfully suggest that Your Honor's question falls into the concept of the post hoc ergo propter hoc principle, which the Jordan case said, let's not follow that logic. And what I mean by that, respectfully, is the fact that one thing follows another does not mean that there's a but-for causal relationship there. And that's why in the Miller case, the court talks about the importance of examining the totality of the negotiations and not just looking at something like timing. Timing is not indicative of causation. What is indicative is whether or not the history reflects a causal relationship between the retention of counsel, the need to retain counsel, and the settlement, and that is not the case here. The chronology is quite clear, and we've cataloged it through our brief. I can address any specific time principles, but again, at this point, unless there are any further questions, I ask that the court affirm. Thank you.
Thank you.
All right. Mr. Sidroropoulos, did I get that correct? Close?
You guys are honorary Greeks. We've got a secret handshake, and I'll show it to you afterwards.
I'm afraid the Greek I am, you are not.
I'm not even that Greek. My last name just really is. But thank you for appreciating my levity. This is the first time I've had the opportunity to argue in front of the Fourth Circuit, and it really is an honor
We're a
and a
friendly
pleasure.
court. You okay?
You are, in fact. Thank you so much. The appellees would have you believe that the insurance company was going to pay the verdict plus interests and costs out of the kindness of its heart on behalf of its policyholder, and that the ultimate settlement that was paid in this case was done not because they were subject to a lawsuit for breach of contract and made aware that their coverage analysis was entirely wrong and ignored binding Supreme Court precedent, but that it had something to do with some other unexplained, unarticulated reason. That reason isn't articulated in any of their briefs or in their claim file or before this court.
Counsel, I don't think they're saying that they would have paid out of the kindness of their heart. I think they're saying negotiations were ongoing. We were gonna get a deal done, and then Bristol Springs filed bankruptcy and filed a lawsuit. That's what, to the extent there was any delay in getting a deal done, that's what caused it.
There's no basis in the claim file or in the record that suggests that they would have paid that amount. The only evidence in the form of testimony is that conversation between Don Larson and Leanna Stinson, which indicates that there's little to no indemnity. That's the only post-judgment evidence in the record.
That's the
regarding-
you're on your own comment?
No, so that's also in the record. That was from a court watcher who we ended up not deposing in the underlying litigation, but they were hired by the carrier to monitor the trial. And the district court was not real impressed with the plaintiff's affidavit. You know, that's ultimately a question of fact, but we certainly don't need it in this case. The key evidence really is that conversation that spurs the hiring of bankruptcy counsel and ultimately coverage counsel, which is that conversation between Don Larson, the frontline adjuster, and Leanna Stinson, who was underlying defense counsel. Argo and Colony understand the economics of litigation. They understand that they can use their superior financial strength to muscle compromise settlements, and insurance companies are certainly entitled to do that before the judgment is entered. But once the judgment is entered, it's time to deliver on the promise to pay or to suffer the consequences, which are written into the law. The reason that hayseeds is an elegant and brilliant doctrine is because it prevents insurance companies from offering modest amounts of money using their superior financial position to coerce small settlements, and when they fail, to not suffer any consequences. And in this case, that's precisely what happened. They failed, and while they were trying to coerce a compromise settlement for less than they owed, my clients went bankrupt.
I don't recall in the record that, and correct me if I'm wrong, but they never declined to settle, or they never definitively said they wouldn't cover the settlement. Is that correct?
There was no formal letter saying, you know, this is our final offer. But the reality is that when they don't meet the demand, that's precisely the scenario that hayseeds is set up for. Hayseeds doesn't require a denial. It doesn't require bad faith. It just requires that a policyholder substantially prevail on a claim for, in this case, indemnity. And I think that's pretty explicit in the case law. My adversary indicated that there was never an excess judgment. That's something that's really interesting because excess judgments are much like this case where a judgment has been entered but isn't covered by the insurance. And what the offer in the amount of the $125 post-verdict is, what it tells the policyholder is you're on the hook for the other couple $100,000, figure it out. The statement that was made by the court watcher that you're on your own is very similar to the State Farm that was made, famously in State Farm v. Campbell, where State Farm told its policyholder, figure it out. You're gonna have to sell your house.
There was a part of the demand that the insurance company took the position that that's not, we don't cover that under our policy. But at the end of the day, in the final distribution, extra money was thrown in toward that claim, wasn't it?
So the ultimate settlement was for $385, which was the verdict of $325 plus interest and costs. By my analysis, that means the entirety of the claim was covered. That was our position. The verdict indicated that there was negligence on the part of Bristol Springs Custom Home for management of its employees and directly against the corporation. That is a covered claim under Charrington in our analysis. And our position is that Argo and Colony, following the breach of contract complaint, agreed because of the overwhelming evidence, because of the negotiation and efforts of plaintiff's counsel, because of...
But my point is, they even threw in the amount that they said that they weren't entitled to pay for.
Which ultimately would mean that we have substantially prevailed. I think that's the conclusion.
I'm looking at it from a hayseeds argument.
Yes, that would entitle us to hayseeds because they have essentially taken a knee on their coverage issue. Before they said it wasn't covered, our complaints filed explaining why everything is covered, and then ultimately they agree and pay the verdict.
But bottom line is, you didn't have to litigate that question with them.
We did litigate that question. I mean, there was not a declaratory judgment action that was filed. There was no court ruling that we prevailed on the coverage issue because they paid the claim that ultimately became unnecessary. We did, litigate that part of the breach of contract case. There was discovery filed and, communications back and forth with opposing counsel. I've run out of time. I appreciate the court if there are no further questions, or if I've responded to Judge Floyd adequately.
Thank you so much for your argument.
Thank you so much.
All right, we'll hear, I suppose, a little bit about the counterclaim, or?
Yes, Your Honors. Again, on the cross appeal, I didn't hear too much dialogue about it from my opposing counsel, so what I'll just follow up is to just reiterate, Judge Floyd, is I do agree that procedurally we would ask the court affirm on the principal appeal. If, of course, the court were to determine that for any reason that it were to reverse, we would ask that this court reverse under the cross appeal or certify the question. I do believe that the law and that the West Virginia Supreme Court would in fact conclude that the proper third-party remedies are already established through the Petrolo line of cases and not the Hayseeds doctrine. Unless there are any specific questions about our cross appeal, I again ask the court affirm on the principal appeal, and if it chooses not to reverse on our cross appeal. Thank you for your time today.
I understand. Well, thank both of you for your arguments today, and the court is going to adjourn for today until this afternoon, I guess, for a ceremonial session. But in the meantime, we're going to come down, as we always do, and shake hands with you. And again, Judge Floyd would love to, but he's going to do so with a wave or something from the bench here.